Good morning, Mr. President, members of the Court. This case presents a stark and well-corroborated record of the sexual violence perpetrated by Myanmar security forces against the Rohingya. What I propose to do today is to focus on how this sexual violence evidences genocidal intent. In the first part, I will focus on the legal principles that link genocidal intent with sexual violence. In the second, I highlight the features that are particularly probative that are present in this case. The Court is already familiar with the atrocious acts of sexual violence perpetrated by Myanmar security forces. I therefore address the facts in a relatively limited manner, just to make clear that the 5 features that are probative are present in this case. I begin with the legal principles. International law recognizes that rape and other forms of sexual violence can reveal a perpetrator's intent to destroy a protected group. This traces back to the first conviction of genocide in an international tribunal, the case Jean-Paul Akayesu. There, the International Criminal Tribunal for Rwanda elaborated the contours of genocidal intent and established for the first time and authoritatively that acts of sexual violence can constitute acts of genocide and reveal an evidence. Sexual violence can reveal an evidence the specific intent to destroy a protected group. The ICTR found that the rape of Tutsi women was systematic and perpetrated solely against them. And in a formulation that has since become a touchstone, it held that, quote, sexual violence was a step in the destruction of the Tutsi group, destruction of the spirit, of the will to live, and of life itself. These determinations underscore 2 propositions central to the present case. First, that patterns of sexual violence are probative of genocidal intent when situated in a broader context of attacks upon a protected group. And second, that sexual violence may itself, by the means by which perpetrators carry out the destruction, constitute genocide. 3 provisions of the Convention are particularly important here. Article 2B, encompassing the infliction of serious bodily and mental harm. Article 2C, addressing conditions of life calculated to bring about physical destruction, and Article 2D, concerning measures intended to prevent births within the group. International courts have recognized that sexual violence can satisfy each provision, and that the manner and circumstances of its commission can reveal destructive purpose. The Akayesu trial chamber explained that sexual violence, quote, formed an integral part of the process of destruction because of the physical and psychological harms to victims and the far-reaching effects on families and communities. In the ICTY, the Ptolemy Appeals Chamber emphasized that the manner and circumstances of the violence are relevant for proving specific intent. This court, in Croatia v. Serbia, recognized that both physical and mental measures can constitute measures intended to prevent births, and that conditions of life calculated to bring about destruction may be shown by patterns that degrade bodily integrity, reproductive capacity, and social cohesion. Akayesu and his progeny help us identify 5 patterns of sexual violence that are particularly probative of genocidal intent. The first is raping of women while killing their children. Such acts extinguish a group's present and future in the same moment and have been treated as emblematic of its destructive purpose. The second is rape accompanied by threats to kill or by killing, revealing an intent to destroy rather than merely to terrorize. The third is public and humiliating violence, mass gang rapes staged before family and neighbors in schools, mosques, or open areas, designed to degrade the group as a whole. The fourth is the deliberate targeting of women and girls of reproductive age, including pregnant women, with assaults aimed at reproductive organs and the abdomen, causing miscarriage, sterility, and trauma that deters marriage and procreation. The fifth is scarring, such as distinctive bite marks that brand survivors, fracture social bonds, and cause enduring mental harm. The evidentiary record supports the finding that all of these 5 patterns of sexual violence probative of genocidal intent are observable in the present case. First, Myanmar security forces routinely coupled the rape of women with the killing of their children. The UN fact-finding mission found that mothers were often gang raped while their babies and young children were beaten, stabbed, cut, shot, or killed in front of them. Many women described the loss of children or unborn children as the, quote, most unbearable aspect of the suffering resulting from those assaults. My colleagues and I addressed numerous examples of rape fused with killing of children in our presentations on 7 main villages yesterday. This pattern recurs across several other locations. For example, in Gayant Chang, in Ye Kat Chang Guason, and in Kiet Yopin. The US Department of State's randomized survey of 1,000 Rohingya refugees in Bangladesh likewise recorded multiple accounts of children beheaded or otherwise killed while their mothers were raped. These methods are incompatible with any benign explanation. They reveal a deliberate strike at both the group's physical existence and its biological continuity, squarely engaging Articles 2B, 2C, and 2D. Second, the Tatmadaw often explicitly declared an intent to kill their victims while raping them. On Monday, Mr. Suleiman provided several examples. And consistent with this hallmark, many victims were in fact killed after being subjected to sexual violence. Examples were shared yesterday. This pattern repeats itself in Yekat Chang Guason, Bahut Chang, and many other villages. Moreover, Tatmadaw soldiers testified that commanders ordered rapes that were accompanied by killing. One describing the clearance operations carried out by his unit in Mangdao and Butidang explained that, quote, when we clear house by house, there were rapes when we clear, and admitted that some of the women were killed after rape. Another soldier testified about sexual violence he witnessed in Taung Bazaar, confirming that troops were, quote, ordered to rape women, and describing how soldiers, quote, put the gun at the victim's forehead and killed right away after raping them. Rape followed by killing reveal an obvious intent to destroy. Third, Myanmar security forces conducted sexual violence in public and in particularly humiliating and brutal ways. The mission identified mass gang rape as a, quote, notable pattern, with incidents in which up to 40 women and girls were raped or gang raped together. Assaults were in open areas, in large houses, in schools and mosques, in forests, in military and police compounds. Frequently, rapes occurred in front of family members, including husbands, parents, and young children. The mission reports that a, quote, total of 80% of incidents of rape corroborated by the mission were of gang rape, and 82% of those gang rapes were perpetrated by the Tatmadaw. Incidents of rape and sexual violence were also carried out by members of the BGP and the Myanmar Police Force and ethnic Rakhine, although considerably less so. Beyond the 7 villages addressed yesterday, public and humiliating gang rapes were perpetrated throughout northern Rakhine, including in Kiet Yopin, in Puint Piu Chang, and in Maungin Hanut, as well as in Gayant Chang. Fourth, military forces regularly targeted women and girls of reproductive age, including pregnant women, inflicting reproductive injury. We addressed numerous examples yesterday, and others are recorded in Kien Chang, in Ga Sang Kyu, in Yu Sheika, and in Ka Mang Sek. The UN fact-finding mission and medical organizations recorded mutilations and other injuries to reproductive organs, miscarriages, prolonged genital bleeding, permanent damage requiring surgery. Survivors reported an inability to resume sexual relations or bear children, and widespread fear of marital rejection and social stigma. These are precisely the physical and mental measures the jurisprudence recognizes as measures intended to prevent births under Article 2D. Fifth, the Tatmadaw routinely sought to visibly scar and brand rape victims. The UN fact-finding mission and medical professionals recorded distinctive bite marks on the cheeks, breasts, and thighs, and mutilations leaving permanent scars. Forensic analysis confirmed violent bite marks on the face of a 15-year-old survivor and found that a, quote, substantial portion of women and girls had been bitten, indicating an intentional practice akin to branding. These findings are probative of serious bodily and mental harm and of the purposeful creation of social stigma that deters marriage and childbearing, falling within the mental measures embraced by Article 2D. Across these indicative features, multiple methodologically distinct sources converge with the UN fact-finding mission. The UN Office of the High Commissioner for Human Rights reported that more than half of women fleeing the 2016 and 2017 operations that it independently interviewed were victims of social violence and documented genital stabbing and other mutilations consistent with, quote, rape to death. The US Department of State likewise confirmed, based on its randomized survey, that Rohingya women and girls were subject to, quote, widespread sexual assault and rape during both waves of clearance operations. Respondents similarly reported, quote, exceptionally violent attacks during the rapes, and several individuals from different villages witnessed soldiers cutting off the breasts of women they raped and mutilating genitals and other parts of bodies. Mr. President, Myanmar's security forces' crimes of sexual violence against Rohingya women and girls achieved their intentions, the destruction of group life. The fact-finding mission concluded that survivors of sexual violence are less likely to procreate, less likely to marry due to stigma and ostracism, and in some cases, rejected by spouses. It described the broader social damage to the Rohingya's community, their capacity to live, to heal, and to reproduce. A multidisciplinary study published by Legal Action Worldwide in 2023 documented permanent genital damage affecting fertility and severe psychological injuries that have left survivors in extreme distress nearly 6 years after the clearance operations. That research found that the systematic nature of the sexual violence damaged the Rohingya social fabric in 3 mutually reinforcing ways. The ostracism of female survivors undermined cultural identity. The powerlessness of men to protect them eroded their social role. And the forced reorganization of family units and lineage weakened future social alliances, including marriage, within the community. In short, the architecture of Rohingya social life was intentionally weakened, with consequences that endure and compound. These are physical and mental consequences contemplated by Articles 2B, 2C, and 2D. Taken together, these facts form the kind of pattern from which courts infer genocidal intent, as Akayesu and subsequent jurisprudence confirm. Before concluding, I address briefly Myanmar's contention that accounts of sexual violence should be discounted because they do not account for ARSA attacks. Even if, contrary to the evidence, Myanmar were to substantiate its claims concerning the ARSA threat in every village that suffered clearance operations and sexual violence, counter-terrorism operations do not justify rape, gang rape, genital mutilation, or the killing of children during sexual assaults. As Germany, France, Canada, Denmark, the Netherlands, and the United Kingdom observe in their joint declaration of intervention, I quote, "Sexual and gender-based violence is not capable of advancing any military objective. When it is pervasive, methodical, and directed at a protected group, it can provide compelling evidence of specific intent to destroy a protected group." Members of the court, the sexual violence inflicted on Rohingya women and girls was purposely destructive of the Rohingyas' physical integrity, reproductive capacity, and social cohesion. Its methods are hallmarks of a campaign to destroy a group in part. They satisfy Articles 2B, 2C, and 2D, and reveal the specific intent that the Convention requires. Sexual violence of the scale, character, and methods serves no military end. It is an instrument of destruction. I thank you for your attention and respectfully request that Mr. Lowenstein be called to the podium to continue the